Most commercial tenants assume that when their lease ends, they can just stay in the property, but that only exists because of one legal concept, security of tenure. And depending on how your lease is structured, you could either have a legal right to stay or to be forced out completely. In this video, we will break down what security of tenure is and how Section 25, Section 26, and Section 30 of the Landlord and Tenant Act 1954 control everything. So what is security of tenure? This is a statutory protection for commercial tenants. It gives two key rights. First, the right to remain in occupation after the lease expires, and second, the right to request a new lease. So instead of the lease ending on its expiry date, it continues automatically by law. But this only applies if the lease has not been contracted out, which many modern commercial leases are. So why does it matter? Without security of tenure, a tenant can be required to leave immediately at lease expiry. With it, the tenant gains time, stability, and negotiating power. But landlords lose flexibility. They cannot simply recover possession without following the statutory process. Briefly comparing both positions. For tenants with security of tenure, you can stay and ask for a new lease. The downside is that rent can increase and renewal is not guaranteed. Without security of tenure, you have no right to stay and may have to leave immediately. For landlords with security of tenure, you have less control and more legal steps. The upside is you can still raise rent and refuse renewal on legal grounds. However, without security of tenure, the full control to take the property back at lease expiry. Let's have a look at Section 25. This allows a landlord to take control of the renewal process. They can either propose a new lease or oppose a renewal. The notice must be served not less than 6 months and not more than 12 months before the termination date specified in the notice. That termination date cannot be earlier than the contractual expiry of the lease. Once served, it sets the legal timetable. Let's look at Section 26. This allows a tenant to initiate a renewal. The tenant serves a request for a new tenancy. Again, strict timing applies. The request must not be served not less than 6 months and not more than 12 months before the proposed start date of the new tenancy. But if the landlord has already served a Section 25 notice, the tenant cannot use the Section 26. Let's look at the grounds for refusal. This is the most important part. Under Section 30, the landlord can only refuse renewal on specific statutory grounds. These fall into two categories: tenant fault grounds. A. Failure to repair the premises. B. Persistent delay in paying rents. C. Other substantial breaches or leases. The second is structural or management grounds. D. Suitable alternative accommodation can be provided. E. The tenancy is a part of a larger property and letting the whole is more viable. And then looking at non-fault and landlord intention grounds. F. The landlord intends to demolish or reconstruct the premises. G. The landlord intends to occupy the premises themselves for business purposes. These last two, redevelopment and owner occupation, are the most commonly used, and importantly, even if the tenant has done nothing wrong, they can still be required to leave. So let's have a look at a practical example. Imagine a tenant running a successful retail unit for 10 years. The lease expires and they request a new tenancy under Section 26. The landlord responds relying on redevelopment under Section 30, ground F. They show plans and a genuine intention to build. Even though the tenant has complied with all lease terms, the court is likely to grant possession to the landlord. The tenant may receive compensation, but again, they still lose the premises. So contracting out. Here is the key risk many tenants overlook. Security of tenure can be excluded entirely if the lease is contracted out of the Landlord and Tenant Act. The tenant has no right to stay, no rights to renew, and no statutory protection, and many modern leases include this. So if you don't check at the beginning, you may have no protection at the end. Security of tenure is one of the most important protections in commercial property law. It can secure your business location or leave you exposed, depending on how your lease is structured. If you're entering a lease or approaching expiry, understanding the sections of 25, Section 26, and Section 30 are critical. If you enjoyed this video, we'd be grateful if you please like, comment, and subscribe.